I'm going to just get things underway here. My name is Steve Sinas. I'm an ICBA board member. Very happy to have you all here. This is our series of events called Keeping Bench and Bar Together. The motivation behind these events is to keep our members informed as a member benefit about how courts are operating, keep them in touch with judges, and keep us all connected. It's obviously been a very hard year. It continues to be difficult in many ways. So we appreciate everyone showing up. It's quite a turnout tonight. We are going to get underway, and I'm going to turn it over to Judge Garcia. He's going to provide his commentary first, and then Judge Dunnings will provide hers, and then we'll have a question and answer session. So without further ado, I've already cleared it with the judges. They don't need any introduction. You all know who they are. If you don't, then maybe you should study up on that before you got here. But if you've been around, you know these two judges very well. And so I'm very happy to have them here. And so I'll turn it over to Judge Garcia. Thanks for being here and take it away.
Well, good evening. Thanks for having us. I'm kind of billed as the chief judge, and I, certainly have been the chief judge of both the circuit and probate court this is my fourth year now in that dual capacity. I served 2 terms as chief judge before that for the probate court. So, this has been billed as, me trying to kind of bring a perspective as the chief judge of our courts. And I thought in deciding what to talk about this evening, other than a few folks that I see on here, I know Mr. Nolan has lived and knows the history of our county courts and the prior chief judges, probably back even before I took the bench. But I wanted to give you some perspective of what it means to be a chief judge and what a chief judge does. I've been fortunate to have a supporting cast of Judge Dunnings here as the Chief Judge Pro Tem, which as she and I have been, during the pandemic, it's been so much of a task that it really has taken more than just one person as a judge to tackle some of these issues that we've had to deal with. All of our judges have rallied together to problem solve what we've had to problem solve over the last year. But, many of you, and I know that when I was a lawyer back in the day, I really didn't know what the chief judge did. I mean, I knew that the chief judge spoke for the court and was in charge of the operations to a certain extent, but you don't get a real appreciation because you don't see what happens. You don't see the administration of the court. You might feel it a little bit when you come in through the front door, but you really have no idea from a day-to-day basis what it means to administer the court. So I thought I'd give you kind of a little bit of a perspective, a little bit of a history lesson, and perhaps a little bit of peek behind the baseball thing, behind the scenes. I joined the bench in 2000, and if you look on the wall, if you ever get back, if you ever get in here again, in terms of the jury room, we have all the pictures of the different judges from the different eras, And if you look at the picture for the class of 2000, when I first got on the bench, I'm the only one left from that time. Everyone else has retired and has gone before me and into retirement. And some of the judges have passed on, and we have a lot of friends that are still about, but some have passed. And so, it's kind of a different perspective for me now looking back. When I joined the court, Peter Houck was the chief judge. And every chief judge has their challenges. Every chief judge has their projects. And it just sounds like it's something they do aside from, doing their bench. But until you're on the bench or until you understand what really takes to administer the court, you don't really appreciate each of the chief judges for what they've done. Now, if you recall, you may not recall, some of you probably don't think about this, but Chief Judge Houck was really in charge and charged with the task of bringing the courts together. Back in the day, we didn't have the Veterans Memorial Courthouse. We had 2 judges over by Dimitri's. We had a couple of judges down at the City Hall. Even before that, after we got kicked out of City Hall, then we were at the Town Center building. You had judges in Mason. You had judges, and in the old courthouse, you had judges in basically a facilities garage out there. I remember when Judge Harrison was out there. So what Judge Houck had to do is he had to organize the community to support the building of a consolidated court building. And that was an incredible task. It was an extraordinary task to get all the different people together in order to get the funding and then the planning and then the logistics of moving all of these judges and staff into one building. That was a huge undertaking and something that really took up just about all of Judge Houck's time. And as I remember, Judge Houck, certainly had time for us when we were in the courtroom. He still had a full docket. I don't think he took a reduction in his docket take, though the court rules allow for a 30% reduction in your docket if you choose to take it. I don't think he did. And I don't think any of the chief judges here in Ingham County have done that, though we probably should have. So that was Judge Houck's challenge. And we can look at the Veterans Memorial Courthouse and remember that that really was built because of the hard work that Judge Houck put in as chief judge. Judge Collette took over for Judge Houck once Judge Houck left. He was the chief judge pro tem, and in those days, that was kind of a logical progression. And Judge Collette managed the operations here in the new court building. And I served as Judge Collette's presiding judge of the family division. And Judge Collette oversaw the re-engineering of the juvenile justice system here in Ingham County. He was instrumental in that, in our leadership of that. Certainly, it was something that I was a part of, and I can tell you, we passed a millage. We fully funded the juvenile programs here. We changed from kind of a circa 1972 probation department into a state-of-the-art evidence-based program, which quite honestly is second to none in Ingham County, and Ingham County second to none in the state, and quite honestly used as an example across the country as an organization that provides this kind of programming very effectively to reduce recidivism rates. And Judge Collette had other challenges too. There were, certainly every chief judge, we all get sued. Every time the court gets sued, we're usually named as a party or have to manage the litigation in that respect as the head of the court. We're the CEOs of the court, so to speak, on the administrative side. In any case, Judge Collette had some challenges during that time. I don't need to go into too much of it, but not only do we have to manage the administrative things that come on with the court, but we have to also, we're first of equals as chief judges, and we have to manage the inner workings of the bench and the personalities involved. And so it can be challenging from time to time. And I know that Judge Collette served as chief judge in that respect and had some issues there. Judge Lawless took over once Judge Collette transitioned away, and Judge Lawless did an absolutely fabulous job in leading the court forward in many different aspects of as we expanded the court in terms of the juvenile justice piece. A lot of dynamics when it came to expanding staff, and she had some challenges. And I think the one challenge that she had, a lot of us have to manage, some PR things. And Judge Dunnings might surely know more about this than I do, I think. But Judge Lawless was around when Judge Dunnings was hired as the front of the court. I think, no, that was Judge Collette. And then she was made the court administrator under Judge Lawless. And, Judge Lawless had a few things. She, I think one time a referee had treated someone not so well who was breastfeeding or needed to breastfeed. And that kind of caused a ruckus down here at the court building. And I know that with a lot of skill and a lot of good common sense, Judge Lawless was able to address the issue. And I think we had a sit-in down here of folks who were breastfeeding came to protest in the front of the court. And I know that Judge Lawless really handled that quite nicely and just really operated the court on a very even keel. Had a lot of challenges, but really continued the good work of the court. And for myself, I'm going to point, I guess, to two things in terms of challenges, or actually opportunities. One we've mentioned is the pandemic. In dog years, a year of a pandemic is 7 years as chief judge. I'll tell you a story about that. In the first weeks of the pandemic, if you remember back in March of last year, you know, we made a decision early on that we were going to stay open as best as we could, even if it was for a few hours, because we felt there were some essential services that needed to be provided, that if somebody didn't have access to the internet, couldn't understand Zoom, didn't have email, didn't understand what to do, was afraid, wanted to be able to come to the court building. You know, if you needed a personal protection order, we still wanted to be able to have that door open to you. If you needed to file a petition to have your loved one taken to the mental health hospital, we wanted to be able to personally serve you by having you come through the door. If there was an issue that had to do with your child and it was an emergency, a true emergency, an essential case, and you felt like you just needed to come to the court building, we wanted to be open for you. So early on, we made a decision that no matter what, that door would stay unlocked, that we would have some personnel here, that we would have a judge here, sometimes two, to be able to deal with you in person if need be. That was a decision we made straight up. And I don't think many jurisdictions decided to do that. I think a lot of courts just shut down and said, email us, make an appointment. We'll let you in by an appointment basis. Come back later. We didn't do that. And I'm not suggesting that we did it the right way, but that's what we did. And that took a lot of hard work by our staff and our managers and our judges to make sure that we were able to stay open. So if I can take you back to that first week that the pandemic hit. So, you know, everybody learned a lot by going through this process, but at the beginning, that first week, this is an inside baseball story. So just let's keep it among us, though it's being recorded, I'm sure. That first week, the county called a meeting of all the managers countywide, had to have a meeting. Well, I was busy. I wasn't going to go to some stupid meeting. No, I mean, I had another meeting. I had something else to do. Judge Dunnings actually said, you know, hey, I'll go. I'm fine. If you want to go, go ahead. So she goes to this meeting. I know that Morgan Cole, I see her on the screen. She was there. And all of the managers, I thought it was just, you know, maybe department heads. No, it was all these middle managers, front of the court, juvenile direct, all the managers of the court, all the managers of different departments across county. And they all stuffed themselves into a huge conference room at the county building. And they had a meeting to go over what? To go over the COVID virus and what we're going to be doing about this. Well, guess what? Somebody at the meeting had COVID. So everybody at the meeting, at least from our standpoint, from the court standpoint, needed to be in quarantine for 2 weeks. And so me and the administrative secretary, Adrian Mertens, were the only ones, I think, in administration that could come to the building because everyone else was in quarantine for the first 2 weeks. That was fun. That was hilarious, actually. The other thing that happened was, you know, the Supreme Court had left it to the judges to kind of get a feel for how things were going to be going initially, but they started getting some feedback across the state about how it would be helpful to have some guidance and some guidelines. Well, I think it was I believe it was a Tuesday night after this really started to get going, and we were putting together a way of going forward. You know, when you get old, sometimes you got to get up in the middle of the night to go to the bathroom, right? So about 1 o'clock in the morning, I wake up, and my usual way is I kind of lean over and see what the heck time is it, and I look at my phone. So I pick up my phone and I see these messages on there, email messages. And so of course I check them. If you don't check them, then God bless you. But so I check them. Well, of course, I see the email from the Supreme Court with the guidance, with the orders. This is what you got to do to stay open. And so you can't do anything until you comply with this order. And it's a laundry list. So now I'm up all night. By 8 o'clock in the morning, I'm at the building and I'm directing traffic. And we put in place by that next morning a protocol where we could stay open under the court's orders and make sure that we kept our promise that that front door was going to stay open. So that's the kind of stuff that we went through during the first part of the pandemic. And then since then, I mean, things that stand out that you probably won't hear about, Judge Dragonshut, in her own way, took the time, I think it took her a couple of days, she made masks for everybody. And when I say she made masks for everybody, she made a lot of masks. So the judges had masks, staff had masks, a couple of other folks who knew what they were doing, they made masks. So before our administrators could secure masks, all the employees that had to come to the building had masks made by the staff who made masks. I call out Morgan Cole. She was ahead of the curve. I still have, Morgan, the super industrial strength, big, huge container of hand sanitizer that you brought my office that first week. And she had one for every of the courtrooms back here, this huge jumbo size thing of hand sanitizer. Who knew we needed that? And who knew you couldn't find that after a certain time? Also, we had 1,000 masks that she had ordered right out of the box. So right when we needed to open, we had to have masks. Not only do we had to insist people have masks, but we felt we had to provide people with masks who wanted to have access, who didn't have a mask. And without Morgan Cole thinking ahead and ordering all these masks, we wouldn't have had masks those first couple of days or those first couple of weeks. George Strander, same thing. We were able to secure supplies and masks and hand sanitizer and line up protocol and make sure that people knew what they were doing from day one. And it was incredible. From the folks at the front of the court to our juvenile court officers, everybody pitched in and everybody worked hard. We had a lot of folks who, this might sound strange, but they were very nervous. Like, for example, in our intensive neglect services program and our juveniles, in the juvenile probation department, we had clients that were nervous about not dropping. That sounds strange to you. They wanted to be held accountable. They actually relied on the drops to keep them from, slipping and going back to using drugs. And so when the DHHS said, we're not going to be swabbing anybody, we're not going to be doing urinalysis testing anymore, our juvenile court officers stepped up in those areas. And we actually came up with a protocol where we would use swabs, and they would go to the front door and they would leave a testing kit on the front door, and they would walk back and the person would come out. You'd text them, they come out and they'd do the swab, they put it in there. And we would continue to do the drug testing remotely, without any contact, in order to make sure that our probationers and
Thank you. No,
with our respondent parents were able to keep up and continue the programming that they had. We had things, we had a lot of staff that were going to have to be working home remotely. Our IT department did an incredible job by issuing laptops with access to our systems, so that, for example, if you call my office and my secretary's operating, judicial assistant's operating remotely, she's set up in her basement where she can answer my phone from her house. She can get on her laptop and schedule from her home. That just didn't happen. Our administrators, Mr. Strander and his staff, and Morgan Cole and her staff, were able to get people remote so that we could continue to operate even as we were trying to reduce our footprint within this building, so that with a skeleton crew, we could fully operate the court. And during this period of time, Judge Dragonshut really took the lead in terms of the Zooming. I mean, she had the Zoom down straight right out of the box. And she was the judge upstairs that had said, okay, I'll take the watch. And she was here every day. Of course, I didn't see her because, you know, she'd come in and go up to her office. And her court reporter was, at one point, they figured out how she could be remote. So she would be at home, zooming in, taking the record. And Judge Dragonchuk would be in her office doing what needed to be done and available to sign orders. Then, of course, we decided to rotate judges. So we'd have two at a time. I see Judge McCormick here. And I call her our Zoom judge because, of course, as you recall, she was appointed, what was it? I think it was in February or March of, I think she took the bench right a week or two before this all started. And she jumped in and was able to be very effective early on in helping us with the Zoom and the in-person things that we were doing. And so that was an incredible challenge. It was tiresome, but it was rewarding. The second thing I want to say, and I mentioned it because I mentioned Judge McCormick and it reminds me to mention it, is that the other job that you have as chief judge is onboarding the new judges. And I've had the privilege of doing that 4 times in 4 years. Judge Dunnings, Judge McCormick, Judge Wanda Stokes, Judge Carol Koenig. When you onboard a judge, you don't just show up and you get issued your black robe and you just start doing what you do. The entire administration is there to welcome the judge, to make sure that the judge's chambers are to their liking. It's almost like, it's not as dramatic, but you know, when the president shows up to the White House, everything's moved out of the White House and then the new president has all their stuff in and it happens in 24 hours. But we don't do that. It's not all that dramatic, but it's the same kind of thing. You know, we make sure that we try to paint the office. We get what that judge needs. We try to figure out what that judge has to have in order to do the things the way they'd like to do them. We help them with answering some questions, basic questions, and it's a big process. And it's been a rewarding process for me and something that I'll point to as kind of a highlight of my career as chief judge is to be able to onboard the four judges that came on in this last 4 years. They're all exceptional in their own way, and I've gotten to know them very well because I've been that welcome wagon person, and I feel a connection to them that I probably will keep with me for the rest of my career, if not my life. One thing I want to leave you with, though, before I turn this over to Judge Dunnings, is that what you all think as lawyers is that, well, you know what, if I'm fortunate enough to be appointed, or if I get elected as judge, I get my gavel, I get my black robe, and I'm a judge, and isn't that great? Let me tell you something. It takes about 5 years to make the transition from being an attorney to being a judge. About 5 years. That's what they say. Now, the 4 that I've mentioned certainly have, all have very great learning curves. They're able to do a lot of things that you see seamlessly, but it takes a lot of work and effort, a lot of long hours to be able to walk into that courtroom, to be able to make those kinds of decisions and to make that transition from being an advocate to being a jurist. So I would ask each and every one of you, please, though they don't really need it and they would never ask for it, I'd ask for patience in a certain respect, because each of these judges, who are all outstanding in their own way, are under a lot of heavy lifting now in order to make that transition is to be a jurist first and an advocate or a lawyer in their past. It's a big difference. And you, again, because they're so good, you don't see it, but I do. I see how hard they work and the long hours they put in order to make it that seamless. So hats off to each one of them. I think we have a lot of stars here in our county, and those are our 4 newest, brightest stars that I ask you for your indulgence if you think that maybe things aren't running as smoothly. And I give them extra credit because being a new judge in a pandemic, I mean, please, poor Judge McCormick didn't get an investiture. I haven't forgotten about that. We haven't even been able to take a picture together. Usually we have that picture done. I haven't forgotten about it, but she doesn't. Judge Koenig, same thing. Judge Stokes, she was able to make a transition before this hit. But, like I said, this has been hard even for a seasoned judge. It's been hard to make this transition, but these judges have made it look very easy, on top of everything else they have had to do in order to make that transition from practitioner to the bench. So that's my presentation. I didn't want to, I can talk about my own stuff if you like, but I thought you would appreciate at least a perspective as a chief judge and get a little inside baseball stories that you can kind of war stories. I mean, if the local bar can't have some war stories to pass along, I don't know what it's worth for. So I gave you a few war stories and hope you enjoy them. At this time, though, I think my partner in crime, Judge Shauna Dunnings, one of the first person I onboarded, the person who, the second judge who was who was an administrator I worked for. The first one was Judge Lawless when she was a probate registrar and I was a judge. Both of the administrators I was able to work with have become judges, and she's a fantastic judge. She was a great administrator, probably one of the best administrators we've had in Ingham County. I'll turn it over to her, and she can let you know what she'd like to talk about. Go ahead, Judge Dunnings. I'll look forward to see what you have to say.
Thank you. I think I'll take the opportunity to transition it over to Zoom and try to get some meat and potatoes. We've got a lot of practitioners here. I'm kind of preaching to the choir when I look at the group, but you have all participated in proceedings via Zoom. And one of the things Judge Garcia mentioned, and we're going to give Morgan Cole kudos again, SCAO gave us our Zoom licenses long before the pandemic. And Morgan made sure we were all set up and had our licenses in place and were ready to go. The only problem is we never used them. So Morgan ran around and got us all Zoom ready. And it made our transition a lot easier than others. I was on a different seminar meet and greet last week, and it was interesting to hear one of the courts say, we didn't have our Zoom and it took us a while to get it up and running. We didn't have that problem. But now moving forward, what does that look like for the probate court? First of all, every judge runs their courtroom differently. So it's going to be important for you to communicate with the judge you're appearing before to figure out what their practices are relative to Zoom, in-person hearings. As Judge Garcia said, our courthouse is open, our courtrooms are open, and we do have people coming in. Initially, it was only come in if there's an emergency, but I have people showing up now. Last Thursday, I had 12 people show up. For purposes of Judge Garcia and I, we share both probate work and family division work. So we split our docket with both probate and family division work. Both dockets have time limitations or performance factors that we are encouraged to comply with, meaning, have certain stages of your case completed within certain time frames. So we've always had that to comply with. And then with Zoom, not with Zoom, with the pandemic, we have now had to balance out these emergencies, and many emergencies we have had that are related to COVID, whether it's on the domestic side or on the guardianship side. I see Mr. Kruger here who does work for Sparrow. We collectively, coordinated by Chief Judge Garcia and Morgan Cole, developed a process to allow us to be able to handle emergency guardianship hearings for people that were hospitalized, either due to COVID or not, people that didn't have someone appointed as a guardian, and some major medical decisions needed to be made. They needed to have a guardian appointed, and we had to do that fairly quickly. Our hospitals were pretty full. We needed to be able to assist and process these petitions on an emergency basis. Sometimes life-threatening concerns needed to be responded to. And so we were able to develop a process with our office and the hospitals to be able to get these emergency petitions in, get them heard on an emergency basis. And then back to that performance factor, once you have a temporary emergency guardianship order, you have to have that resolved. We are expected to have that resolved within 28 days from that hearing. So we had to find places to have those hearings. But through that process, we were able to work with the hospitals, and this is a bonus, if you will, because now the hospitals have video cameras in the hospital. So the respondents, or the people that they're seeking to get a guardianship order over, are able to be seen by the court. And in the past, we didn't have that option. That is very helpful because we oftentimes on the emergencies, you can't get notice to everybody. And it's just important to see. And then there's staffing that was put in place to be able to respond to questions the court had in order to establish that the emergency existed. So that was one of the ways that we kind of had to change the way we do business. And quite frankly, I'm starting my third year on the bench, and I never saw so many emergency guardianships as I have obviously over the last year. So, but with that practice, we've learned a few things, which includes video, having video conferencing available moving forward for staff, the hospital staff, and it makes it much more convenient for them. On my probate side, we have guardianships of developmentally disabled people, and they have to be renewed every 5 years. And we have historically, they're required to participate in the hearing if at all possible. And when I started, I was amazed at how many people they would come in, they're wheelchair bound, severely autistic, the spectrum of medical conditions that qualify them for the designation as developmentally disabled. And now through Zoom, we're able to hold those hearings without taking that ward out of their comfortable area, whether it's their home, their residence. They're able to be in a comfortable environment and participate in the proceedings. And I've seen a huge difference. There's not stress on the staff if they're in the residential placement, or the family members, because there's a lot that goes on in court that affects some of the people that are developmentally disabled, just the sounds, the noises, the light, things that we wouldn't even contemplate. So that, I talked to Judge Garcia about it. I said, that's something I'm going to continue to do moving forward. Now, certainly if, anyone says, I want to bring the ward in, or the ward demands to be brought in, absolutely, they're welcome. In fact, I've had some come in that are not, they're not as severe in terms of their condition. But I intend to continue with the DDs appearing via Zoom because it supports everybody. Pre-trials can be via Zoom. You really don't have to be in court for a pre-trial for me. So there are a lot of things that Zoom has allowed us to learn how to be more efficient with, I think. And with our probate docket, because of the nature of the work we do, you don't always have to physically be here to do it. Now, trials, exhibits, that kind of stuff, and I have neglect and abuse trials frequently, not always with a lot of exhibits, but on occasion I do, particularly where there's injury to some of the people. And so it's critical that you communicate with the assigned judge about how that's being handled. I have a procedure in place in my court, and I discuss it during pre-trials or settlement conferences, requiring the attorneys to work together before they get to court. Novel concept. So that we can have a joint exhibit list for those exhibits that are stipulated to, and then a submission of exhibits that are not stipulated to that will be provided. I have removed the shared screen from my virtual courtroom. I turned it on once because I knew it had to be used, and I'm careful with that because I've had people publish on the shared screen without permission. And obviously that causes all kind of excitement with people when something like that happens. So my procedure was intended to avoid that and make sure that those exhibits that are not stipulated to are handled as they would be if you're physically in court. I have had cases where it was just theoretically impossible to try with people appearing via Zoom. And so we've adjourned it and said, come on in, you got to come in. My courtroom on the second floor is configured to be consistent with the ever fluid and changing rules about how many people can be indoors in a particular place. So I had all of the benches on one side of the courtroom removed. I have a table over there. I use this example because this is exactly what my court was set up for. It was set up for a neglect and abuse trial with one mother, three fathers, and their attorneys, and the guardian ad litem. So that's what the setup is, so that everybody could be socially distanced, and it remains. And when we are able to go into jury trials, because on the second floor, we only have to have a jury of 6 people, 7 if you pick the alternate, it can be done in my courtroom. So there may be some musical courtrooms that occur when jury trials commence, and you all probably got Judge Garcia's notice that we've now pushed back to May 17th for jury trials. And we actually, in my history as a court administrator, we have more jury trials scheduled in the family division than I've ever seen. We have to report out how many jury trials occur. And I was a court administrator from 2013 to 2018, and we never had more than 5 jury trials in the entire 5 years I was here on the family division. We've got, I don't know how many scheduled. In fact, I had one requested again today. So for example, on the mental health commitments, Judge Garcia has a jury trial requested in the hopper. I have one in the hopper. And then we have to balance that with our neglect and abuse cases where children have been removed, and then our delinquency cases, and then the cases upstairs with the criminal defendants that have been incarcerated for 365 days, 500 days or more. So when we start opening up for jury trials, Judge Garcia and all of the judges, we will continue to be working together to kind of prioritize and balance how many prospective jurors we can have in here and how many trials we can have going on. There's been a lot of discussion and a lot of planning and a lot of forethought regarding the jury trials. As the members here today, I encourage you to give strong consideration to request for jury trials. And is that really in the best interest of your clients? Because particularly with, let's say, certain types of probate cases, that it's just not going to be on the priority list when we've got to, handle these criminal cases where we have speedy trial issues, where we've got children in out of home placement, and we're dealing with people's rights. We've got people that need to be under a mental health commitment order that aren't because they're waiting for their jury trial. So prioritizing globally amongst the 9 judges is going to be an ongoing challenge that we have been talking about at all of our meetings. And we ask your patience and understanding as we're doing that. And every case is important to everybody. We understand that. And it doesn't matter whether it's, removal of conservator or trustee or guardian for breach of duty or undue influence or all of those other things that we balance out in the probate court. But certainly, unless there's a risk of harm to the individual or society, those are kind of things that we have to continuously contemplate when we're scheduling, and certainly when the jury trials get up and running. We are also reconfiguring the office. As anybody that's come here knows, right now we're working with Clerk Byram, and the probate court has an employee sitting at the circuit court clerk's office at a window designated for probate court. We have been approved and will be putting up similar barriers in the probate court to protect staff moving forward. And once we get all of that taken care of, and Ms. Cole would probably know what the time frame is, we will be able to open our probate office again and conduct business in our probate office, but provide the protections our staff need moving forward. Because we're all getting vaccinated, but we want to make sure moving forward, we continue to provide safety and our staff feel comfortable. And then another thing along those lines is clarification. I had an attorney asking me about e-filing, and it was on the probate side. And so I clarified, and I want to be explicitly clear. Both circuit court and probate court accept filings by email, which is not e-filing as contemplated by the court rules. There's a big difference. So the e-filing court rules, and that was what the lawyer was asking me about, are not applicable because what we're doing is accommodating, due to COVID, a way of receiving pleadings through email. And I think it's important everybody understands that distinction. And, you know, at some point, we will go back to either the acceptable way, or, you know, I don't know. I leave that up to the people that handle those daily affairs, including Judge Garcia, Ms. Cole, and Mr. Strander, to talk about what it looks like moving forward. But that has caused some follow-up, particularly on the circuit court filing side, because they're not accepting payments. But on probate, Ms. Cole has figured out how to allow payments to come in. And so we have to link up those payments with the pleadings. E-filing, that would all be a part of one, and it would dump right into our case management system. The emailing does not automatically file into our case management system. So every day, our clerk staff have to go through all of those emails, pull them out, and put them over into our case management system. So don't assume because you emailed it at 4:55 on Monday night that it's going to be file stamp 4:55 on Monday night. It will not. It will be processed when clerk gets to it, probably not at 4:57, probably at 8 o'clock the next day. So I think that's important. And I actually, you know, we've been talking a long time. It's 6:15 and this is scheduled to go till 6:30. So I think in fairness, rather than continuing to blah, blah, I'd like to see if anybody has questions. We can open it up for questions for everybody. And then our responses could be more specific to the questions and concerns of the people that have taken time to be here.
Well, thank you so much, Judge Garcia and Judge Dunnings. Very helpful information, very insightful comments from Judge Garcia about the history of the court. So just thank you for all that. It is now time to have your questions answered, or hope to be answered. So the way we can do this, if you want to ask your question, if you have one directly to the judge, you can raise your hand and I will call on people. We have one in the, or I have a direct message from somebody with a question that states, curious if courts have had many petitions for temporary guardians to consent to COVID-19 vaccination. Let me reread it. Curious if courts have had many petitions for temporary guardians to consent to a COVID-19 vaccination.
I've had some. I don't know about many, but I've had some. Actually, I've had some emergency guardianships filed for people that are in nursing homes.
And I've had a few. I think we're set up for more. And I think the idea was that we would do this not just, we try to do it on a quick turnaround basis, same day service kind of thing if need be, and a temporary appointment or a limited appointment or a protective order. These are things we can do fairly quickly. And I think I had issued a press release maybe a month ago that highlighted that for the public, that if your clients need someone to make that decision to get consent, and your client is not in a position to provide consent, we're gonna streamline that to the top of our list of things to do. So you're gonna get a real quick turnaround on those requests.
Thank you. Next question, I'll just read it verbatim. Now that we've seen that courts can operate remotely, will we have a hybrid once buildings can open to full capacity again? Can remote hearings be used for people with disabilities who may have trouble accessing the court, i.e. seniors in nursing home?
Absolutely. I think as Judge Dunning said, there's going to be, and I think what Chief Justice McCormick has said is that, the Zoom is here to stay, and we're going to be able to do a lot of things remotely that we weren't going to be doing for a long time, but for the pandemic. But I will caution everyone to say that, at least from my point of view, we need to get back to the courtroom. Look, our kids first have to go to school. We got to get them back in the classroom. And at some point, you all going to have to come back into the courtroom, because justice really is about the opportunity to find the truth. And it's hard to find the truth, quite honestly, from the screens. It is very difficult to gauge credibility and to make rulings in this virtual arena. It just is. I don't know how you all feel about it. I feel very strongly about it. I mean, mundane things, scheduling conferences, things where people need accommodations, absolutely. But when we're talking about whether to terminate someone's parental rights, and I can't barely hear, or I can't see, or I can't gauge, what the witness is saying. I don't know who's on the other side of the screen with the witness, who's influencing the testimony of the child, who's, we got to get, at some point, we all need to get our vaccines and get back to the court building. That's what we need to do in order to make sure that we're not making a lot of mistakes. That's my 2 cents. Judge Dunnings, what do you think about that?
Yeah, well, I have specific examples. And so to your question, Steve, one of the things that I ask you to be considerate of is, if we're going to use Zoom, some of the elderly people are hearing impaired, and Zoom does not accommodate that well at all. So let's not even talk about being able to turn on Zoom. And I have a Zoom story. One of the other speaking engagements I had, they wanted to hear Zoom stories. And one of my Zoom stories was about an elderly mother who was using Zoom. She was going to be petitioning for guardianship over her grandchild, and was having difficulty with the Zoom and the volume. And her daughter, someone, it looked like it could have been her daughter, whomever, was coming in to assist her. And it was first thing in the morning, and she was coming in to assist her and had not fully put her robe on. And so she gave everybody a morning wake up call while she was putting her robe on to come assist her mother with connecting to Zoom. And so even if you have help connecting, you still may have help with the participants hearing what's going on. And if they come to court, we have headphones that are assisted hearing technology that make a world of difference. I mean, every time I have an elderly person that comes in and can't quite hear, and it coordinates with their hearing aid to turn it on. I don't really know how it works, but they put it on and their eyes get big now. Oh, I can hear it now. Yes. So that's something to consider. And I actually had a hearing with, it was an estate matter. So some of the family members were on Zoom, and 3 of the family members came into court. They were elderly. One of them had a hearing problem, hearing impaired. And she, couldn't hear. She could hear me fine, but she couldn't hear the people on Zoom very well. So we then put the headphones on and had to coordinate, and it worked out well. So that's one thing I would caution you to be aware of. And to Judge Garcia's point, I can't tell you how many times, and it just happened on Friday, I said, who is there with you? And this person picked up their phone and did like that really quick. And the kids were there, sitting at the table, listening to an emergency motion. And it was not something the kids should have been listening to. And I said, go back, scan back slowly. Well, of course, they ran like ants. And so it's things like that are difficult. And then I had another hearing, and the elderly daughter and her mother were sitting there, and it's a case, the attorney's here. And Some of the family members are concerned about this elderly daughter's influence over her mother. This is the one where I'm saying, can you hear me? And the daughter's saying, can you hear her? Well, that defeats the purpose. And so when the mother was prepared to testify, I said, I need her out of the room. So she's not there influencing mother's testimony. And we were not able to proceed. And so they're going to have to come in. But that's a perfect example of sometimes they just have to be here so you can know if they can answer the question without help, because you don't know. They have their device on mute or something, you don't know who's feeding information to them. If they're holding a note on the side that's printed and you see them looking over. So that's the hardest part.
Yeah, I can't imagine some of the things you've seen. If anyone has any other direct questions, feel free to either raise your hand or you could even unmute yourself and just assert yourself here and ask your question. I will just go ahead and ask the general question. Are there any particular pointers you want to give lawyers about how they're functioning these days, how they can help you guys with your role in the probate courts? Any common mistakes, pet peeves, things that just can be done better?
Talk to the other side.
Yeah, it's not a good idea. Let's try that.
I feel like I'm showing my age. I was taught by one of the best attorneys in the world. That's, I'm biased. But I was not allowed to go to court if I had not spoken to the other side. It goes right up there with the other rule he gave me. Every single time you get ready to try a case, read the rules of evidence. It doesn't take long. And so, couple of things. The court rules, they're the equivalent of our Bible. You would be surprised, just about every answer to any question you have about procedures are in the court rules. In fact, when I became a judge, I became acclimated with court rules I didn't know existed in areas of practice that I hadn't practiced. So, court rules, they're your friend. Use them. And in the court rules, under motion practice, there's a really novel concept. The novel concept is before you file the motion, you can send a proposed stipulated order to the other side and say, hey, this is the order I want. Do you agree to that? I don't think anybody uses that anymore. I haven't seen it used. It's right there in the court rules. And then if they don't, you file your motion and say, boom, this was the order. This is what I'm looking for. That's why we're here, Judge. So I would encourage people to communicate and use your court rules. And when you object and cite the rules of evidence. I know there's objections are used during trial to stop the flow. I get it, but I promise you, if you're in my court and you start going on a dissertation as a basis for your objection, I'm going to refocus you and say, what rule of evidence are you relying upon for your objection? That's fine.
Well, and I'll add a little bit to that. I sound like the guy on the front lawn saying, get off my lawn. I mean, I got to say, well, back in my time, but seriously, before we had email, before we had a lot of things, I remember that Fred Abood, I was a young lawyer. Fred Abood called me and said, Rick, this is Fred Abood, and I'd like to make an appointment to come see you. I'm like, well, Mr. Abood, why would you want to come see me? Well, we have a case. We have a common case together, and I want to come talk to you about our case. I said, all right, well, at your convenience, Mr. Abood. Well, he came, he made an appointment. He came and he sat in my office. And he said, well, I think we can get this settled, and this is really all we're looking for. And we had a really wonderful conversation, and we settled the case within about 15, 20 minutes. And I was really impressed by that. It really impressed me that he would take the time. I was just a young, new lawyer, that Mr. Abood himself would take the time, or Mr. Dunnings would take the time, or, Mr. Farhat would have taken the time to make an appointment to come see somebody and sit down and talk about the case before we got in too far, before we spent a lot of money, before we started wrangling and taking up the court's time. But with emails and this, that, and the other thing, now you don't see anybody anymore. You email them or you call them, and now we Zoom them. And now with COVID, we can't get together as much. But once we all get vaccinated and this passes, wouldn't it be nice to get back to just going over to getting your car, go over to somebody else's office and sit down, maybe with your clients, maybe it's not appropriate because your clients are in domestic violence, sit down and talk. Now, my practical thing, we'll talk about Zoom. I don't know how many people tonight are hardwired into their device. Probably not many. Zoom is fickle. It depends on your bandwidth. It depends on your speed. It depends on the reliability of your Wi-Fi. If you're in the middle of a critical hearing and something disrupts that, you're going to zoom out and disrupt things. So Ethernet cable, you get it at, you can get it anywhere. You can go to, any of the big box places. Ethernet cable, very cheap. You got yards of 100 big rolls of Ethernet cable, and you run it from the modem that you have that provides you your internet to your office or to your home, and you hard plug it into your device that you use for Zoom. That'll cut down on a lot of problems. There's so many times where I can't hear you, you freeze, it disrupts the flow of your argument, it disrupts the flow of the proceedings, and it makes it virtually impossible to conduct the hearing. Now, I'm not saying that, your Wi-Fi is going to always do that, but it is a lot better and secure to do it that way. And it's cheap and easy to do. So if you're set up in a home office, just get a big long roll or spooce thing of Ethernet cable, plug it into the back of the router and hard plug it into your laptop. You can use a phone or you can use an iPad. Those are all cute. Get a laptop, use a hard wire, and the connection's better, and you will survive a lot longer on Zoom. Please do that. Please consider doing that. It's a cheap way of making sure that what we're doing here is going to work well, and you're not the reason why we have to take another break because we got to let you try to, call in later. It's a very easy fix.
We are getting close to the end of our scheduled time. I don't have too many more questions, but I guess I had one from my own experience that I'm dealing with right now. There's no secret to any of this. My 4-year-old son went back to daycare for the first time in a year. He did that about 3 weeks ago, and last week he started to have some symptoms, and we got him tested, and he got COVID. And so we are now in this lockdown mode until April 6th. Me and my wife and my kids really aren't supposed to leave our property, I guess, except if we really have to. But I'm just wondering, I guess, to put that more to the timeline going forward, as we transition and more people are vaccinated and you guys are thinking about operating, are you also thinking about how we still are going to have these instances where people just drop out and have to be quarantined for 2 weeks, and how that affects lawyers, how that affects jurors? Just any thoughts on that? It's because I'm living it right now.
We still have to remain flexible. We still have to remain flexible and respectful. There's going to be some of you who don't want to get vaccinated. We have to respect that. Our employees are not mandated to be vaccinated. They are choosing to either be vaccinated or not, and I'm not asking. So, I respect everyone's decision as to what they want to do in terms of their own medical advice and how they're going to operate. But if somebody does have a legitimate medical concern, like they're quarantined, we're going to have to make accommodations. There's going to be adjournments. There's going to be delay. The residuals of that are going to have to last for quite some time.
Thanks.
Yeah, I'm very accommodating to that. And the only thing I would have you do if you wanted to appear is have you coordinate how you'll communicate with your client. that's the only thing during some of the Zoom hearings. Communication between attorney and client, there's a lot of thing now, so they're using that as a way to communicate, but I would accommodate that also.
Well, it's 6:31. I've certainly enjoyed this. Hopefully everyone else has. If there are any final questions, feel free to get them out there. This is your time. If not, I guess maybe since we all can kind of see each other, can we do a little golf clap, round of applause for the judges?
Thank you very much for inviting us. It's a good opportunity to be able to see everyone. Miss seeing people in person, but at least this way we can share. And so I hope it was worth it.
Yeah, it's been tough. It's been tough on all of you. We know that. Here's the secret. Judge Dunnings and I have new carpeting. Now, the rest of the judges are getting new carpeting, but we got it first. You know why? Because what we just did. So here's the thing. I'd like to have everybody come and see my new carpeting. So I'm really proud of it. And so I would invite you to come to the courthouse to see the brand new carpeting. It looks great. Really
It does. It's blue too.
It's blue. It's Judge Garcia blue.
Maize and blue.
So
Thank you,
please,
everybody.
everyone, take care and please come to our next event, which is, I believe it is April 12th, if I'm not mistaken. So please keep an eye out for the emails and come to the next few events we have with the rest of the judges. So thanks a lot for coming tonight.
Thank you.